estate planning is very important. It's something that I've noticed is not often talked about, or it's an area where people just really don't know a lot about. There's some fear, there's a lot of myths. And so the goal with this series is to really help get the conversation started. And so this month, the focus is kind of continuing the conversation. Last month, we started talking about trust and some of the tax implications of trust and estate planning in general. And so this month, I want to continue that. But before I jump into trust, I just want to give an overview, I like to call an overview of estate planning and just kind of what it is, why it's important, and and then, like I said, from there, I'll provide some information, but this isn't designed to be a conversation. So if there's something that I go over that you've never heard of or you don't understand, you have a question, or there's just some questions that you've had in general that you want to be able to get some answers or some additional information, please do so. Now is the time for that. Um, so like I said, with estate planning or planning, I like to, my kind of Latavia definition of it is just, it is making a plan. An estate is, in it's a property, your assets is kind of what you own. So whether that be um, multiple properties, a large bank account, net worth, things of that nature, it's all of those things combined make up your estate. And legacy is defined as a gift by will, especially of money or other personal property, or is something that's transmitted or received from an ancestor or predecessor or the past um, to someone else. And so those are kind of the textbook definitions, but really the planning, it is the action or the act of making a plan and saying, while I'm alive, this is how I would like to live. These are the things that I would like to happen. And then when I pass away, this is who I want to receive things from me, who I want to make those decisions, and how I want my loved ones to be cared for. And so like I said, I like to call it legacy planning, and then to look at it in two different categories. There's planning for life, and in the event of incapacitation or extended illness, what would how would you want to continue living? Would you want to be able to maintain your standard of care? And if so, what have you put in place to make sure that that happens? And so some of the things that come into play for life planning is a power of attorney, which is you granting, it's a form you fill out where you are designating the person you want to be able to kind of act as though they were yourself to make decisions for you, whether they be financial decisions, kind of business, credit decisions. You can determine the extent of the power you want to give them. And then the other is an advanced medical directive or healthcare power of attorney, depending on where you live. And that allows you to designate a healthcare agent so that in the event that you become ill or incapacitated, whether temporarily or indefinitely, you've identified up front, this is the person that I want to make decisions for me or about my healthcare, who has access to that information. And these are, if there's an end stage condition, this is what I want them to do or what I don't want them to do. I want them to consult with the doctors or consult with a certain number of people and make these decisions, or I've already decided what I want to happen versus what I don't. If you've ever seen in shows or heard people say they signed a DNR, which is the do not resuscitate, that's a part of that planning. So those are that's kind of for the life side of it. And then when we're talking about once we've passed away, that's typically where a will or a trust comes into play. And a will, it is a written document that you lay out your instructions for what happens when you pass away, who you want to be the person to execute your plan. So a personal representative, you designate who that is, whether you want to be buried or cremated, if you want to have a funeral, what you would like that to entail, if you own property, who you would like to leave that property to, if you have all of your personal properties, a vehicle, art collection, clothing, jewelry, all of those things you specify in your will. who you want those to be left to. And then with a trust, it does a similar thing, but with the trust, a trust, I always like to describe it as, you kind of think of, you have different buckets. I'm going to put my belongings in a bucket, and then I'm going to say who I want to be responsible for keeping the contents of that bucket safe. And so with the trust, you would create the trust. So we create this bucket. Let's say it's a little Latavia trust. And while I'm alive, I say I am going to be the trustee of this trust. So, but when I pass away, I see my sister is here, so I'm going to use her. I will designate my sister Jasmine. I want her to be the trustee of my trust when either when I pass away or in the event that I become incapacitated and not able to make decisions for myself, then I'm placing her in charge of my trust or of that bucket and making sure the things, the items that I have placed in that bucket, she is responsible for keeping, safeguarding them and potentially making them grow. So you can put real property or like, so land, houses, you can put those in the trust. You can put vehicles in the trust. If you have life insurance policies, retirement accounts, uh, investments, things of that nature, you can put those, they can be titled into the trust and then managed by the trust. And one of the benefits of a trust is you can put in instructions for what you want to have happen while you are alive, how you would, like I said, if you were to become have a long-term illness where you're not able to work, but you put funds aside to cover that, you can put instructions in that trust document which state how you want to, who you want to make those decisions, who you want to make, where the funds are to cover your day-to-day expenses and bills, what you want them to do, who is going to care for your children or other, if maybe they're not minors, but you have adults that you are providing care for, thinking about, well, who would I want to be taking care of them and making sure they're good. As well as in the same document, you can put instructions for what happens after you pass away. So I just said a lot. I want to pause to see if there are any questions. Like I said, I know I just kind of went through that. Like I said, it's a very, very, very quick and dirty overview of some of the aspects of estate planning as a whole. But I want to pause to see if there are any questions.
I have a question.
Yes.
Um, so, would a trust be used the same way as like a lawyer would be, instead of using a lawyer to make sure everything is in place? Is that what the trustee does? And is that the same thing as an executor of your estate?
Okay, no, great question. So it wouldn't be, having a trust or trustee does not necessarily replace having or utilizing a lawyer. Um, you can designate a lawyer as your trustee, but it doesn't have, so I guess the easiest way to explain, so let's say I prepare a trust for you or work with you to develop your trust, and you list a family member to be the trustee. Um, that person that you designate as the trustee, if they're not sure about how to carry out something or just are unsure, they can hire an attorney to help them carry out those wishes or make sure that the trust is implemented properly. And then an executor is the person that's the term used when we're talking about a will. So if there's a will, or if someone passes without a will, then the executor or personal representative is the person who is responsible for making sure your desires are carried out. Does that make sense?
Yes, but to add to that question, then let's say a person who doesn't have a will,
Mm-hmm.
then how would the executor be determined?
Okay, no, that's a great question. So yes, in the event that someone passes without a will, um, let's say if it's a family member has passed away, you have a family member who passed away, they did not have a will, you were close to them, you have a good idea of what they wanted, then you could go to the court and initiate the what's called the probate process, and then essentially request to be appointed as the personal representative or executor of their estate. And so each state has a different process in terms of how they open an estate, but you would essentially fill out a form requesting to be appointed as that personal representative, or you could, let's say within the family, you all want to nominate someone to be the personal representative. You would submit that to the court or the register of wills. In some states or counties, it's called the orphans court. But you would submit that paperwork to them asking for the person to be designated. And in most cases, the court will grant that, and then they will appoint that person as the personal representative of the estate. And then they would have the same responsibilities as if they had been designated by a will.
Thank you.
You're welcome. And I am going to share my screen. I have a slide here just because I want to go provide a little bit more, I guess, detail. And for those who may be visual, let me share my screen. So here, like I said, this is just, I talked through this, but I just wanted to provide something in writing in terms of what a trust is. Like I said, it's a relationship that you create. And there are two types of trust. There's an inter vivos or vivos, which is a living trust. That's one of the more common types of trusts that are created. That's where, hey, I create the trust while I am alive. And it could be a revocable trust or an irrevocable trust. A revocable trust is one that, hey, as long as I'm alive, I can put it in place, I can make amendments to it, I can change it, or I can cancel it out while I'm alive. An irrevocable trust is one where, hey, once you create it, it's in place. The terms you set are the terms that you set. A testamentary trust is one that this would be terms for a trust would be included in your will. And so this is where it's saying, upon my passing, I want a trust to be created, and these are the terms that I want to be included in the trust. And so it would not go into effect until after you pass away. And some of the common reasons or uses for trust is people want to avoid the probate process. Probate requires you to, work with or go through the court to open the estate and have letters of administration and kind of reporting things to the court of what is the value of the estate, what are all the assets, what are the liabilities, reporting that. And in some cases, you have to get permission from the court before you can do certain things. And depending on what's going on, the value of the estate, if anything is contested or you can't find people, it could be a fairly lengthy process. Disability planning is another reason, as I mentioned before, in that trust document, you can spell out what you want to have happen. You can put in the terms for when you would be deemed to be incapacitated, if you want that decision to be made by a physician, if you want that to be made by a panel of people that you choose, in terms of who would make those decisions. And then it gives you more control of your assets or of what happens after you pass away. And then also asset protection. This comes in more so when there's higher value estates where people are looking for, to avoid taxes or some of the other fees that it's like, hey, I want to avoid taxes. So I'm going to move my assets into different types of trust. Okay. So in terms of potential tax issues, as I mentioned, one of the reasons that people use or want to use a trust is to avoid taxes. And so regardless of whether someone had a will or they use a trust, you have to file a final income tax return for a person when they pass away. So even in death, the IRS still makes sure that they are tracking us and that you filed the taxes. And so depending the gift tax rate, this is based on, like I said, I have some federal and some Maryland-based numbers here. And so for 2024, the federal, exemption is $13.6 million. So if it's there, the estate tax would go into effect. You would be charged taxes on the estate once the estate reaches or exceeds that $13 million threshold. In Maryland, I know I have some people in the DMV area. In Maryland, it's currently 5 million, an exemption of $5 million. So if at the time that you pass the value of your estate, all of your assets, if they total less than $5 million, then there would not be an estate tax charged at the federal or the state level. And for if you're concerned about, okay, if somebody if they leave property to me or if they leave me money, am I going to have to pay taxes on that? There are some states that have an inheritance tax, and that's essentially if someone leaves me money, then I potentially have to pay taxes on the amount that I received. But even with that, there are thresholds that you have to exceed for that to be applicable. And in most cases, that estate tax or inheritance tax, I'm sorry, is not applicable if let's say if you leave something to your children, to your spouse, it's kind of like the direct familial connection. It's exempt. There are exemptions for those taxes. And I am not a tax attorney nor a CPA, so I'm going to stop there because I don't want to end up telling you something wrong. But if you would like to hear a bit more about some of the specifics on kind of the tax rates and percentages and how that works, I would encourage you to watch the session from last month where I had a CPA on and we kind of went into a bit more detail about those the specific tax rates and percentages. See a question. Yes, using insurance policy is one way to minimize or avoid taxes. And so something to keep in mind there thank you for bringing that up. When we're talking about life insurance policies or really anything where it's an account that has a beneficiary listed, keep in mind that whether if you pass without a will, if you have a will, or even if you do a trust, the proceeds of that policy are going to go to whomever is listed as the beneficiary. So an example, if I have a life insurance policy and I list my sister, I was using her before, I list my sister as a beneficiary, and I create a will and I say I want the proceeds of my life insurance to go to my daughter. It doesn't matter that my will says I want the proceeds to go to my daughter because that doesn't pass through the will. The insurance company is going to release those funds to whomever is listed as the beneficiary on that policy. The same with if you create a trust. If you do not update your life insurance policy or the beneficiary to list your trust as a beneficiary, they're not going to release those funds to your trust, even if you have said, kind of the large portion of your trust in terms of funding is based on this life insurance policy. If you don't update that, it's not going to work. So there's things that I always like to say, there's things that don't pass through a will because they kind of stand on their own. So life insurance, retirement accounts, pension accounts, investment accounts, essentially, like I said, anything where it has you designate a beneficiary, you want to make sure that you keep those updated and that they reflect your current desires. There have been situations in the past where there was someone, they were married, they got divorced, ended up remarrying, and never updated their life insurance. And then when they passed away, although their intention was for those proceeds to go to their current spouse, they didn't make the updates to the necessary paperwork. And so the former spouse received the proceeds And unfortunately, legally, there is nothing that that current spouse could do because they were not listed as a beneficiary. And I bring that up as well because I had a client when we were going through their planning, they were saying they wanted that essentially they had a conversation with their spouse. The plan was that, hey, I'll use your life insurance to help pay for the funeral. You do the same for mine. And the conversation I had is like that's great. I think that's admirable that you have had that conversation. However, um, because they were also, it was a matter of trying to split some things up. It's weak, even if you write into the will, I want X amount of money from my life insurance policy to be used to pay for my funeral expenses. There's no guarantee that that will happen because when you pass away and the company releases that money to whomever's listed as the beneficiary, it is their money to do with what they want and use it how they please. And you have passed away, you can't control it. And like I said, that's another benefit, I would say, if we're looking at kind of the differences of a will and a trust. If you have a trust and you have funded the trust in terms of you have actually put money into the trust itself, you know, of an account, and you state that upon my passing, X amount of dollars is supposed to be used to cover my funeral expenses, and it needs to come from account A, then that is instructions that are binding even after you pass away. And so one of the big or common mistakes or misunderstandings when it comes to trust is that people will create a trust and they have all these instructions. They've thought through everything. It's detailed. It's easy to read and understand, but they forget to fund the trust. And if you don't fund it, then you just have this nice document that really is ineffective. And so when I say fund the trust, that means, like I said, if we're talking about putting property in the trust, you wouldn't actually need to take the steps to transfer title or deed. Let's say if you're of your home, you need to go through the process of doing a deed transfer and retitling the property from your name or whomever's name is on it into the name of the trust so that the trust now owns the property. If it's specific, if it's a matter of cash or a monetary amount, you need to open a bank account and title that bank account, you know, the Latavia Trust, and then put money into that account. If it's investment accounts, you need to work with, if you have a financial advisor or there's a brokerage you're working with, you want to make sure you put those into accounts that are titled and owned by the trust and are managed. So that way, when things happen and you want it to actually, you want funds to be dispersed, there's actual funds available to be dispersed. And that the same goes if you've heard the term trust fund babies, or you know, on a lot of shows, you hear one of the shows I liked was Power, and at the end of that series, when the father passed away, the attorney was reading to the family, you know, what are the terms, you know, did the will reading, things of that nature, and one of the stipulations for the son was, okay, you have access. I've left you X number amount, a sum of some $1 million that was left to him. But the condition for him being able to access the funds was that he needed to graduate college with a specific GPA. And, you know, there were terms, conditions on the release of that money. And so that is one of the other benefits of a trust is you can specify when you want someone to receive the funds or how often or what are the conditions for which they can receive the money. And so you can also do kind of some future planning. So if you have children that, or even if you want to provide for grandchildren, you can say, hey, I have this sub trust for grandchild number one, that there's a X number of money available or whatever's available in the trust. They have access to it when they reach the age of 18 or when they reach the age of 21. Some people have gone so far as to say, oh, once they graduate with a specific GPA or once they get married, then they can have it. If it's a matter of blended families, sometimes it's specifications of this money will go to my daughter, but not their spouse. So you can get as detailed as you would like, but there's like I said, it gives you more control in terms of what happens in the terms and timeframes of when things will be dispersed. Or you could just say, hey, I want it to be, you get monthly allowances of X amount, or when you reach this age, here you go, the money is yours to do with what you want, and the trust is now dissolved. It's also beneficial if there's family property that it's, hey, we want to keep this in the family, then that's where having a trust could be beneficial because it's okay, we're going to put the property in the trust. We're going to establish a bank account or some kind of funding source to make sure that there's money to cover taxes and maintenance and upkeep for the home, and then putting stipulations on when or if the home can be sold, or if it's sold, it has to be sold to someone in the family, and you can even specify from this bloodline, or whether it can be someone who has married into the family, like I said, so on and so forth. But I want to pause again to see if there are any questions about anything that I have talked about, or just any other questions you all may have about trust.
So I have a question. So you had mentioned earlier that people create trust, but then if they don't put the items in the trust that is to be delegated, then basically it's a waste of time. Sounds like that's what you said.
It can be, depending on one of the things as a kind of a backup, or kind of a backup insurance plan to that, is one of the things that I do when I'm preparing a trust-based plan is we do what's called a pour over will. And so what that does is, if for some reason something that did not get that was not actually, the trust wasn't funded, maybe a portion of it was, but there was something that got left out,
Mhm.
the pour over will, so that it essentially kind of it serves as a catch-all of anything that was not, for some reason it failed through the trust, or it didn't get funded through the trust. We put in instructions for, this is what we want to have happen. So that is one way of kind of as a backup to it, so that it's not a complete waste. Um,
Mhm.
the other thing is always just, I tell people when they're thinking about this, kind of the same of, if you have an employer where they say every year for annual enrollment with your health and your benefits. So I would say reviewing your things annually, and at any time there's a major life event, reviewing your documents to make sure that they still reflect your goals and wishes.
Okay, and then just one other question with that is, it sounds like earlier when you said you have to make sure those things are in place. So let's say if I wanted to give my house to my children once I die, would I need to go ahead and transfer that deed now, or when would I have to do that?
No, that's a great question. So really it depends on I'll say it depends on if that's what you want to do, and also the relationship you have with your children. So if the goal is to leave the home to your children, you can you can put that in your will that you want the home to be left to them. Or you could go ahead and transfer the deed to them, but doing so with the understanding that if you retitle it to your children, it is now legally their home. And as much as I want to say and believe that nothing like that would ever happen, unfortunately, I know differently. And so that's why I say make sure that you are clear on what you want, and that your children understand that, hey, I'm putting it in your name just to kind of make life easier later. But it's,
Mhm.
that with the understanding of like, hey, it's still my house. I'm going to live here. You all aren't going to do that. And the reason I say that is there was a situation where there was someone who she was trying to help her daughter and her daughter's family out. They moved in, and she transferred the deed, changed, retitled the home to her daughter's name. I think her daughter and her son-in-law's name. Things were not the greatest between she and, I guess, the son-in-law, to the point where the daughter actually filed eviction proceedings and ended up evicting her mother from the home, and did it in a very, I would say, shady way. But by the time the mother realized what was happening, the eviction had already gone through, and she didn't really have any legal remedy because she was no longer the legal owner of the home. And so that's a more extreme case, but I share that just to say that that is an option, but just make sure you're clear on the dynamics of your relationship with your children. On a more positive note, using my family as an example, that is what my grandmother did. She had the home. I think my dad. She retitled the deed to my dad and so transferred ownership to him. So when she passed away, that wasn't in. There was nothing that needed to be done with respect to the house because ownership had already been transferred, and they also didn't have to go through probate process for that either.
Okay, so therefore, if I really wanted that to happen, I could specify that in the trust that at a certain time I would like it transferred. For example, just the house. I would like to it transferred. I could specify. I wouldn't have to do it now, but as long as it's spelled out in the trust, then it would happen at that time that I specified, correct?
Yes, that is one way to do it.
Okay.
Yeah.
Okay. Thank you.
No, you're welcome. And I see a question in the chat about transfer on death deeds. I think that is a good tool, similar to even the thought of, going ahead and transferring ownership to the home of the home while you're still alive. So if anyone's not familiar, a transfer on death deed is essentially, it creates a beneficiary for the house. So it's saying that upon you complete the document saying, upon my death, I want ownership to be transferred to this person. They're very good for planning purposes and also a way to avoid probate. The challenge with that is not every state offers transfer on death deeds. Maryland is one of the states that does not have or does not recognize transfer on death deeds. And I want to make sure I'm reading the question fully. So yes, it could be a substitute to a trust, or even, leaving the property or transferring the property through a will. So it's just, if that is something that you're thinking about, you want to check to make sure that that is an option for the state that you live in. And it could be beneficial. It's also, again, I guess, a bit of a more safe way as opposed to transferring ownership while you're still alive. In terms of and speaking of transfer on death, I did want to also point out, and this applies whether you're planning to go a trust or a will route, is you can set up transfer on death or payable on death for your bank accounts as well. And so what that does is it essentially does the same thing. So if I have say you have a checking account, you're the sole owner on that account holder on that account. You can call the bank or go online. Most of them have forms that say, hey, I want to set up a payable on death. And what that does is you list a beneficiary. I'll say, hey, upon my death, I want to list Jasmine Howard as the payable on death beneficiary for my bank accounts. So what that does is with the time that I pass away, she would go to contact the bank, provide the death certificate or in what other it's generally the death certificate. They want proof of that it has occurred, and an identification to say, hey, I'm the person listed. And at that point, the bank will release the funds to that person. That is something else that you can do that is another way to avoid probate or minimize something that has to be there, because then it makes the funds available right away, as opposed to if there is not a payable on death designation on the account and there's no other account holder, then you would have to essentially petition the court, open the estate, and get what's called letters of administration from the court, where they're giving the financial institution permission to release the funds to the personal representative. And like I said, that takes more time and it requires more involvement. And where that could be detrimental is, let's say I have a checking account where I have set money aside where there's enough to cover my funeral expenses or any just kind of the last any other expenses kind of for day-to-day living for things around the house. But if I'm the only account holder and I haven't set up that payable on death, then my family can't get access to those funds until they open the estate and get that permission from the court. And then that could cause someone else to incur debt or certain things to not happen. So like I said, that's something that you can do now that in most instances does not cost any money because the banks don't charge you to set that up. So that's one thing that you can do as well as a substitute.
So I have a question.
Okay.
So I'm in the middle now where my dad is 80 years old and he wants to transfer his house to me.
Mm-hmm.
I don't want that to happen now because then I'm taking on the debt and the taxes. If something happened to him, it's my house. So I'm taking on all the legal ramifications. So with the transfer by death deed, wouldn't that be a better route to do that instead of it being transferred to my name now?
Yes, that could be and where do you live?
I live in South Carolina.
In South Carolina. Okay, I'm not
We
certain.
both live in South Carolina. Yeah.
Okay. I'm not sure if South Carolina has transfer on death, but if they do, then that is certainly an option. Another option, and if you don't mind me asking, is his wanting to, I guess, transfer ownership, does it have anything to do with like Medicare, Medicaid planning?
No, no, no.
Oh,
He's
okay.
ill and he was just trying to look ahead. Um,
Okay.
to it's three of us and I'm the oldest, and so he's trying to split things up so each one of us will have a responsibility for something in his estate.
Okay. All right. So yeah, if South Carolina recognize, hold on, I'm gonna try to look that up right now so I can give you an answer in real time. If they do, then yes, that is an option. Another thing is if it's a matter of like he just wants to make sure that hey, I'm gonna get things in order,
Yes.
then what you could do is advise him to have a will created and or a trust. So South Carolina does not allow transfer on death deeds.
Okay.
Um, but you can do it for like cars or things. So since that's not an option, one thing that you could do is he could work on his estate plan, do a will-based plan, and in the will specify that he wants to leave the home to you or to you, the three siblings, the three children equally.
Mhm.
And if he does it that way, then once he does pass, you all can then go through the process of through, opening the estate and then actually having the deed transferred, um, ownership transferred to you all at that time so that you're not taking on any of the responsibility while he's still alive.
So
Another option would be if he wanted, he could put it in a trust. But even then, it's a matter of who would he, if he wants to leave it to you or talking to you or your siblings about it, then he also probably would want one of you all to be the trustee of that trust. And so there would still be the responsibility for it while he's alive.
okay. And what would you recommend? Okay, so we were talking about bank accounts. I'm of age and I want to put one of my daughters on my account in case I'm ill. But the issue is they would have access to it also. And
Mhm.
so, and the person at the bank told me just to be careful because all of our names are JS and we're in the same bank. And so we're just trying to figure out what's the best route because I have both my girls down as beneficiaries. So what would you recommend in that case? If you get ill, how can someone have access to your account to do your everyday, um, is that a power of attorney?
So yes, that's it. So if you don't want to go the route of adding them as a joint owner of the account, then you would want to have a power of attorney where you specify, and all states have a kind of a standard form that they've created for power of attorney, and you can do it where you just say, hey, I'm giving kind of a full power of attorney. They have the right to do all the things, or you can specify the things you want them to have the ability to do on your behalf. And you can have the power of attorney go into effect right away as soon as you sign it, or you can have a provision in there where it says it goes into effect in, when I become incapacitated or when a specific situation happens. Um, and I tell people about that because there's the question of, okay, if I give them power of attorney, then even though I am of sound mind and I have the ability to do things, they also still have the right to go and make decisions, open accounts, withdraw things on my behalf, kind of a carte blanche, depending on what is provided in that power of attorney. So you can do it. That's another option of essentially giving them power of attorney and then putting conditions on when it goes into effect. So that way, if you were to become ill, then it goes into effect. And then once you recover, you can have you can specify that if the doctor says, hey, I am now back in sound mind and have capacity, then the power of attorney is no longer effective.
Okay, thank you.
Mhm. Are there any other questions? Okay, let me make sure.
I guess I will ask one more question. So, as you were talking, I Googled which states does allow the transfer on death deeds.
Mhm.
Well, this one in particular for real estate in North Carolina is not listed in that. So, I'm not going to ask you to go into any detail, but I would hope then there are some other options along that line where you could do something similar to that.
For property, or
Yes.
well, with this, I guess the other options would be you could create a will and specify that who you want the property to go to upon your passing. You can do a transfer, essentially while you're alive, you can transfer ownership or deed the property to someone else. You could do it where you instead of saying, instead of Latavia is giving the home to Jasmine Howard, I could deed it to where I say I'm transferring, it's transferring from Latavia to Jasmine and Latavia as tenants in common. And so that way it adds someone else's name to it, but it doesn't remove you as an owner while you're still alive. There's some states that allow what's called a life estate, where a life estate deed, where you can essentially grant yourself a life estate in the home or in the property, which means you own it for the duration of your life. And then upon your passing, it would go to, in this case, you could say to your child or to one of your children. That's another option. And then the other would be retitling, creating a trust and putting the property in the trust. But then it's a matter of who do you want to be the trustee, because someone is still responsible for the trust, especially if there's a mortgage or, the mortgage would still need to be paid. Property taxes still need to be paid. It still needs to be maintained. So that doesn't necessarily alleviate the piece of responsibility for it while you're alive, but those are some things you can do to, I guess, expedite the process upon when you pass in terms of who would receive, who would have access to the home or ownership of it.
Thank you.
You're welcome. Okay, well, we are coming up on an hour, and I like to, like I said, limit it to that just in terms of being respectful of time. But I appreciate you all for joining. this month's conversation. It is being recorded. And so within, if not by the end of this week, early next week, I'll have it on my YouTube page, so that if there's something you want to re-listen to, or if you want to share it with someone who wasn't able to attend, you can do so. It'll be a public link. And then, like I said, there in the previous months, we talked about, I kind of went a bit more in depth about estate planning and the different aspects of it. In September, the focus was in terms, I had a financial advisor who joined to talk about some of those aspects of working, how they work with an attorney to develop your estate plan and your plan, your kind of the financial aspects of it. And then last month, like I said, there was a CPA who joined to talk about some of the specifics or nuances of taxes and how that plays a part into your planning. But thank you all again, and I do hope you all have a great evening. I will put my information